Well, good afternoon, everyone. Welcome back to another episode of Speaking Legally, where the legal meets the cultural. We are here every week, 4 p.m. Eastern Standard Time, with our expert attorneys. And this show is brought to you by Destiny Designers University TV. We have Royce Russell Esquire, and today Edward Pichardo Esquire will not be live because he is doing what they do, litigating a case. But we're glad that you are here with us. There's so much going on in the news. We're going to get into two of the top stories and then get into where the legal meets the cultural. But before I do all of that, I'm going to kick it over to our co-host, Royce Russell Esquire, so he can say hello.
Hey, thank you everybody for having me once again and tuning in on Speaking Legally. This is where the culture and the legal meet. And there's a lot of things that we need to discuss. We all know that the Floyd prosecution, police officer Chauvin, is being prosecuted, and we're hearing all the greatest and the latest on major networks. But are they infusing some of the culture and some of the courtroom dynamics together, or are they just saying what they can only see? And sometimes what you see is not really what is happening, it's what's happening behind the scene. And so we're going to put together a show here that discuss where the culture and the legal meets in this particular case. But first, we definitely have to get some of our local news.
Absolutely. And the first part of that is the fact that everyone has basically been waiting with bated breath, I should say, to find out what's going on with the financial capacity of our country. So apparently, this just happened literally right before we came on air. Help is on the way.
The motion is adopted. Objection, a motion. Without objection, a motion to reconsider is laid upon the table.
All right, Gloria. I mean, it's a big deal when you have a moment like that, right?
Yeah, and I think you could see that in Nancy Pelosi. She's been sort of dancing lately. She's just so, she's so thrilled with this package and what they were able to do. And again, I think this tells you an awful lot about Joe Biden. He was in the Obama administration. His people were there. They learned from what they believe they did the wrong way. And Biden said all during the campaign, I promise you, I'm going to get you help. You'll remember this. Help is on the way. And the two things they always talked about were getting the vaccines in your arms and getting relief on COVID. And I think, people in the administration right now are breathing a sigh of relief because they've got one big part of that done.
All right, so that's the big news for today, literally happening in real time, that there will be additional relief. I believe it's 1.9 trillion that has been approved. So that's pretty major. And the $1,400 stimulus checks for the Americans who are eligible, the unemployment benefits. So there's quite a bit for everyone to be aware of when this comes. So what do you think about that, Mr. Russell?
Well, I can tell you the new generation, what do they call it? The or something like that? They got this down pat.
I can't keep track.
Yeah, I know. They got this down pat. They were already counting eggs before they were happy. They knew it was going to get passed. Some are planning education around it. Some of those folks out there that need this check to live off of, they are planning around how they're going to pay their bills and what they're going to use this stimulus check for. And those that are on unemployment are thankful that there will be a continuation of some income coming in. I'm watching the Democrats stand up and actually walk a straight line, put one foot in front of the other, nonstop. The train is moving. I mean, the vaccines, there was no reason for us to doubt whether or not it would make its way through the House and the Senate in order to get the vaccines out and the production and things of that nature. I think that was a no-brainer because nobody wants to be left holding the bag or being labeled as the group, the political group that held up the healing of this country. It is the economics that where the trouble spots are, and the Democrats have stepped to the plate. They have swung and they had hit a home run, and money will be coming soon. So kudos to them.
Kudos indeed. And this had to be across the aisle. So this was an opportunity for some way of working together, because we know things have been very contentious. So kudos, yes, for the agenda being passed. We want to acknowledge those Republicans as well who understand that this is not one of those issues where it divides us, it unites us, because we have to get things back on track. Hey, Richard, welcome to the show as always. So here's what I would say. As people get their checks, don't necessarily use it all at one time if you don't have to, so that you can save for a rainy day. We know that this recovery and healing is going to be a process. So you want to also culturally, let's be wise in what we spend it on, because we don't know what's coming in the rest of 2021. So we want to make sure that we're conscious of that, and that we're getting advice on what we should be doing with our money, those who are on furlough, those who out of jobs, unemployment. So we always advocate that you talk to experts that can help you really maximize your return on that $1,400 investment that some families will get. Yeah. And with that being said,
yeah, I think to your point, in the bigger picture, we talk about the stimulus and what that money looks like as far as 9 billion, 19 billion, trillion. But for the family that is getting that money, $1,400 will help you. Obviously, it will not hurt you, but it definitely will not heal you. So slow and steady, the turtle rolls, in reference to using that money, because we don't know if another helping hand will be coming America's way, not because it's not culturally defined.
Absolutely. So just use wisdom, and hopefully that will put some more life into the economy, especially those who are in business and looking to employ other people, or just making it from day to day. This has been a rough period for everyone, and we acknowledge that. But culturally, we know if America gets a cold, we get pneumonia. So just use wise judgment in the things that you do with the support that you receive. So in addition to that, there's a lot going on in the news. We're not going to get to all of it, but we're definitely going to talk about.
We need to get to what's important, and we know what's important, because I know where you're going.
Exactly. Well, this one we couldn't quite ignore. I don't know. You can go from being loved in the media in 1 second and then shot down in the next by one fell swoop. I'll let the video do the talking on this, and then we'll get your insight.
Tonight, New York Governor Andrew Cuomo on damage control after 2 more women have come forward alleging inappropriate behavior.
I'm not going to resign because of allegations.
Karen Hitton, Cuomo's former press aide during his time as HUD secretary, told the Washington Post and WNBC that he crossed the line in 2000 when he asked her to his hotel room.
He started asking me personal questions. I was uncomfortable with that conversation. So I stood up to leave, and he walked across from his couch and embraced me intimately. It was not just a hug, it was an intimate embrace.
Today, in a call with reporters, Cuomo said that's not true.
She has been a long time political adversary of mine, highly critical for many, many years, and has made many accusations.
On a list, a former Cuomo aide told the Wall Street Journal that during a 2014 reception, the governor hugged her, kissed her on both cheeks, and wrapped his arm around her lower back before taking this photo.
I take pictures with people at ceremonial events. I never meant to make anyone feel unwelcome in any way.
In recent weeks, 3 other women have accused Cuomo of unwanted advances. He said he never touched anyone inappropriately. Today, he added that he wants the Attorney General to finish the investigation into their allegations.
Let's get the findings, and then we'll go from there. But I'm not going to be distracted by this either.
But calls are growing louder for the three-term governor to step down, who's also caught in a separate scandal for allegedly undercounting nursing home deaths during the pandemic. His administration has denied any wrongdoing.
And Kathy, tell us about that growing list of people calling on the governor to step down.
Well, Kate, that's right. The list is growing among top state lawmakers on both chambers of the state legislature. This includes the Senate Majority Leader as well as the Assembly Speaker, both asking Governor Cuomo to step down. And according to the AP, Governor Cuomo says he's not going anywhere. They'll have to impeach him. Kate?
So, OMG, this is a loaded one that we see going on in New York State, particularly, because Governor Cuomo was all over national news as one of the leaders of saving America, right? Because of his leadership during COVID, and now the scandal about the nursing homes, and now the scandal about these accusations. I don't know. What say you, Mr. Russell?
Well, clearly, I don't know what the truth is, and I will probably never know what the truth is. But when we look at politics, we got to look at placement, and we have to look at power. Here's a gentleman that is very powerful, and you do not reach those heights without pulling your power, without also being protected, without bullying in some shape, form, or fashion, or being assertive in a fashion that a lot of people may not like. And so therefore, you're always vulnerable. And no one is flawless in any shape, form, or fashion. Now, what comes to my mind when I look at this scenario is no one came forward when he was on the TV set day after day, hour after hour, minute after minute, giving his leadership as to COVID, him and Governor Murphy, right? And we saw that go on for a period of time. Thereafter, no one raised their hand to these allegations, truthful or not, when we had COVID managed. All of this came about, at least from what we see, and I can only go on what we see, when the first rock was thrown at the glass window in reference to nursing homes. Somebody said he's wounded. Somebody said it's controversy. Somebody said that the time is right now to come forward. And so I look at who came forward first. Is it coincidence, or is it created in that the person that is running for, I believe, Manhattan DA, brought forth these allegations? I don't know. Is it coincidence or is created? Then others are now following suit. I would tell you that I predict that he's not going to get impeached. The majority of folks of color that is sitting up in Albany, they may blow some smoke about what should happen, but it is unlikely that it will happen. Is this created to prevent him from running for president? I don't know. Is it all about timing, that now the timing is right? Before he was too powerful, he was leading the country, and so therefore we could never say anything about him? I don't know. But is the who, it's the what, and it's the wins that I look at. Who is making the allegations? What are the allegations, and when are they being made? And then the question becomes why. And when I look at all of those answers to all those questions, I don't know if it actually is all what it appears to be. That is my opinion, and it's only my opinion.
Absolutely. Well, the truth always comes out. As my West Indian family would say, it comes out in the wash or the rinse. So we'll find out what's going on with this particular situation. I did find it interesting because, like you said, he's had such a national, international platform that it didn't come out sooner. Just interesting. My mother has her own opinion on how she feels all of this has transpired. I'll save that for another day. But we will watch it unfold.
Let me ask you this question. You said that your grandmother says it comes out in the rinse and the wash. I would add another. It comes out in the dryer as well. Because it's brought on you. It's brought on you. It's brought on you. It's brought on you. Step down. The heat of improprieties. That also, that bright light that is beaming on your head, that heat will also bring the truth to the surface. And he's saying all the right things. He's saying, Attorney General, have at it. You know, but let's get it done so I can get on with my business. Maybe that is arrogance. Maybe that is there's nothing there. And the reason why I star arrogance is because we see the arrogance right in front of us with the trial that is taking place in Minnesota.
Well, it's definitely interesting, and I hope that we come to a point where we do get the truth. It would be unfortunate if it were found out to be true. And it's just, once again, you know, when you're not creating the narrative and somebody else is, it's interesting how you're on one side of the spectrum in this particular instance, because there were a lot of favorable stories, and then now folks are, you know, twisting. But we're just bringing that up because it is the top of some conversations. Some people are more concerned about the relief that we just mentioned, concerned about healing from this coronavirus, and that's top of mind. But just being aware of some of the things that play out. And I really wanted to just highlight it because it's interesting. We let one person get off with doing much more damage than this potential person has done, with lives being lost, literally, and they didn't get impeached. So it's interesting that the call for impeachment is coming up. I am a proponent that women should definitely be protected. The Me Too movement has opened up the voice of so many. I just always feel that, you know, due process should be due process, investigate and find out if it's true or not. And then if it's not, you pay the consequences no matter who you are. So that's just my opinion.
I would agree.
So now,
I would agree.
So now we're going to move into what's really at hand, where the legal meets the culture. I want to shout out Reginald, Deborah, Kevin. Thank you all for tuning in as well. It's always great having you here on the show. And we're going to get into a discussion around jury selection. We've talked about the importance of being a juror, the importance of understanding how culturally we need to participate in the system as it is so it can be changed. If we just, I'm not going to be bothered, we get announcements like, throw it in the garbage, and we're just not even at the table, it allows for other things to happen that create another, I would say, onslaught of challenges for us getting justice when we do have trials that impact who we are as African American, Latino, any indigenous people here in this country that haven't always gotten a fair share when it comes to how the criminal justice system operates. So, Mr. Russell, you did a little background that we're going to share and then talk about something that's in the news as well. And we all need to pay close attention to this particular case in the jury selection. So over to you, Mr. Russell.
Well, we know that I've always preached about jury selection. Well, not necessarily jury selection, but doing your part as participating in the criminal justice system and in the civil system by becoming a juror. And I've always tied that in with cardiac arrest, a tactical guide on how to handle unlawful police stops, and how those experiences sometimes keep you from wanting to participate in the criminal justice system, and gives you the right to raise your hand and say, I've had a negative encounter with a police officer, so therefore I do not want to participate in any criminal trials. And we can discuss whether that is by design or that is happenstance, and we will discuss that in a little bit. But what we're seeing on trial today and what we are being exposed to, if you look at the news, is what it means to be a juror, how do we get certain jurors, and whether or not justice could be handed down by jurors. And all of that is being viewed when we look at the trial of the police officer, Derek Chauvin, who killed George Floyd by having his knee on his neck. So before we get into the real details of that trial, let's just have an overall discussion and, as we're going to call it, edumacation on reference to jury and what a juror is. And simply, the juror is the person, or the juror or juries are the people that supposedly reside in your community. And they are people like you and I, citizens, that are what we call the kings and queens of the facts. Now, the judge is the king or queen of the law. That means the judge tells you what the law is, tells you what the elements of the law is. If a man takes product from a grocery store and does not pay for it, that is stealing. Stealing is defined as taking property from an establishment without paying. That is just an example. That's what a judge will tell you. He will give you the instructions. The prosecutor will lay out what they believe are facts of actually what happened that day that leads them to want you to come back with a verdict of guilty because they have proven that Mr. A went into the store and took product without paying. The defense will present what he believes or she believes are facts to have you come back with a verdict of not guilty. Presenting facts that says that this person did not leave the store without paying, or the person did not have the product, or the person paid and you're just not seeing that transaction, but other factors to get you to side with not guilty. And the jury are the people of the community that determine what is fact and what is fiction. And based upon their determination of what is fact, then they come together, and it has to be unanimous, right? If there's a jury of 12, there have to be 12 people that come together that say, we believe that the person is not guilty. We believe that the person is guilty. They don't have to rationalize it. They don't have to speak to what elements they thought that the prosecution made or met, or what elements that defense counsel was able to defeat. They have to come back with a verdict, guilty or not guilty. Now, they're allowed during this process to have questions, to ask the judge to read back the definition of the law, to ask the judge to have the court reporter read back certain testimony, maybe of the victim, store owner, maybe of the accused, what people call as the defendant. They cannot have read back closing arguments, opening arguments. And that's the stuff that we see on TV, where the prosecutor or the defense is making this long speech about what the facts show and what actually happened and their version of what took place, and defense is doing the same thing. And we're very engaged in that. But that's not evidence. That is not testimony. Testimony is a question and an answer under oath. So if I ask you what time it is and you never give me an answer and I move on to the next question, then when the jury comes back and says, Judge, we want Mr. Russell's testimony read back when Miss Grant asked him what time it was. And if Miss Grant never got that answer from me, and I never gave the answer because maybe she was distracted, or maybe she had another question that was more important, then the jurors are left with a void. They are now left with that there is no time, that the question is unanswered. So the jury is very, very important as to what they see are the facts. They are the trier of fact. That's the word you hear, trier of fact. They determine what facts to accept and what to reject. Credibility, what to accept, what to reject. If it's forensic evidence, well, that's usually what we call stubborn evidence. It's on paper, it's there. how do you apply it to what you want to do? So what you're seeing throughout this trial, and what you're going to see for many days to come, which is very, very important and is the cornerstone of our criminal justice system, is that jury selection. And so let me go on further, Dr. Grant, before we have our little colloquy. When we look at jury selection, the prosecutor and the defense have what they call preemptory challenges. And what that means is that I can challenge whether or not I want this juror to sit on this particular trial. Now, that could be done without cause. That means I don't have to have any particular reason. I could just say no to you, no to you, and no to you. But those challenges are not unlimited. Those challenges, I only get a certain number of them. So if you have a room of 60, and usually when I try in cases, whether as a prosecutor or whether as a defense counsel in state court, what they do is they fill the room up with about 60 people, maybe 100 people, knowing that there's going to be a group of people that are going to raise their hand and say that they can't sit for this case for whatever reason. Some are lying, some are telling the truth, some don't want to be bothered, some brings back memories. So those people kind of make their way out. And then you're left with a smaller population of people. And within that group, you then get a chance to pick your jury. So as I was saying before, there is what we call preemptory challenges. And so what does that mean? And once again, it's challenges for which you can strike a person, say, be gone, boot, kick you, get out of here. We don't need to see you. You're not serving as a juror. And I don't have to give you any reason at all. I laugh sometimes because
Wow.
It's almost like being an employee working for an employer in certain states. They can fire you with or without cause. And then there are challenges. Well, we won't say challenges. People that remove themselves for cause. So, Dr. Grant, before you interject, I'm a prosecutor. I have a pool of these jurors here. We get down to maybe 30 of them that we have questioned. And we could talk about what those questions are about. But let's say we get to, the judge puts 12 in the box, and then he puts another 8 on the side rail. So we got 20 to choose from. And after we get finished having a conversation with the jurors, the judge says, all right, defense counsel, who do you challenge? Defense counsel goes first and says 1, 3, 5, 6, 7. And those are the seats that the people are sitting in, potential jurors. And then the prosecutor goes 3, 4, 5, 9, or what have you. Sometimes what takes place is that the prosecutor and the defense counsel gets together and say, look, you know that person over there, number 8, is really, really bad for this case. Why are you going to force me to use one of my challenges to strike that person when you know we both know that that person should go? Maybe there's a meeting of the minds and that person is gone. Some people play close to the vest and they want to allow that to happen. They make you use your challenges. So you have an understanding when I say challenges are not unlimited. When it comes down to felony cases in New York, you have 20 challenges. And for all the cases in New York, you also have 2 challenges for alternates. And so in any case, after you pick the jury of 12, you still need 2 alternates just in case someone gets sick, someone gets ill. You don't know. Somebody goes on the internet, seeks some information that they're not supposed to. And so the alternates come in. Each side, prosecutor and defense, get 2 challenges as the alternates. So it's 20 if it's an A felony, murder. It's 15 if it's a B or C felony, robbery, possession of drugs with intent to sell. It's 10 challenges for anything else. And we see the same thing in New Jersey. New Jersey, they automatically start out with 20 challenges for murder, assault, aggravated assault, for major robberies, and 10 challenges for everything else. So that's important because those challenges determine whether or not you become a juror or not, despite what you say. Might be a great fit, might be a perfect person for the jury. And then here I come and say no to Dr. Grant, no to Richard, no know the Kevin. So that's what we're going to be looking at down to the trial of police officer Derek Chauvin in the George Floyd matter. And we're going to go further. Dr. Grant, you want to interject?
Yeah, I just want to make sure that we're understanding and underscoring once again the importance of showing up for jury duty. While a lot of people culturally see it as an inconvenience or I really don't want to go or be bothered, it's important to have enough people so that if someone gets rejected, that there's still the high probability that you'll have people who come from your community who understand the case from a different lens than having a jury that does not look like your peers, that may not be the best suited to help your attorney, especially if it's the defense attorney, fight on your behalf. And that's just critically important to just keep reminding our community that jury duty is a part of your civic duty. So it's not something to just take lightly, and we're going to see this play out in real time.
And you know what's important here, and really need for us to talk about this in a way that we're viewing this trial that is taking place, the prosecution of Derek Chauvin in reference to killing George Floyd, and use it as a case study of what it means to be a juror and how important it is. Because when we talk about the cultural and the courtroom and the legal coming together, this is where it all starts to a certain degree. And let me speak to the cultural. I make no bones about it. When we look at negative interactions with people of color, with police, that leaves a bad taste in your mouth. That bad taste carries over, not only when you see police and they might be in the right, but you don't know it, you automatically go to, I know that they're doing something wrong. That carries over when you're in the courtroom. So now you're in the courtroom. And as soon as the judge says, oh, this is an undercover sale involving police officer, or a police officer says that they saw a gun, then everyone that's had a negative interaction, and I'm underscoring everyone because it's really not everyone, raises their hand. And so that's half the jury pool. And so now this person's of color sitting there and knowing what we know about gentrification and knowing what we know about certain areas being more populated or becoming more infiltrated and populated by people who are not African American or Latino. Now you have maybe a circumstance where it is not a jury of your peers, because the people that live in the neighborhood that know the neighborhood are no longer on the jury because they raise their hand, because they're taking this negative interaction and they may be using it as an excuse to not participate. I have had a bad experience with bananas. I ate too many one day. It really, really made me sick. I don't necessarily like bananas because of that. The smell makes me nauseous. However, I can eat a banana if you put it in a shake. I can eat a banana if you put it in a smoothie. So, are there ways to have that negative experience and be able to overcome it as it relates to you and see what's going on in a particular case? I would say yes. The conspiracy side of me says that this is all by design. If we create the negative interaction, if we create the frustration, then we create the disengagement. The disengagement means that then you're no longer involved in the criminal justice system or the civil justice system, and therefore you're not participating as a juror, and therefore I can have my way when it comes down to cases in the courtroom. I might be wrong. Who am I? I just been a prosecutor for 25 years and been practicing law somewhere in the prosecution and defense side for 25 years and just happened to author a book. It could be all in my brain. I will accept that. It could be smoke just going up my nose. I can accept that too. But I think there may be a link. And I think that is caused problems in our community. The rubber meets the road. And so we're going to see this in this trial. And so let me just say one other thing, Dr. Grant. In playing out this preempt challenges where I get 15, you get 15, and we're going to strike people here and we're going to strike people there. We've always known, and when we highlighted Thurgood Marshall, we talked about Peyton v. Mississippi in 1947, I believe, case where a black man was indicted by an all-white grand jury, convicted by an all-white grand jury, and Thurgood Marshall was able to argue that the criminal justice system at that time was a reflection of systemic racism. How could you have this when you had close to 12,000, almost 13,000 African Americans that lived in a community of 34,000, and you had more than 25 qualified African Americans to participate in this trial, in this grand jury, and they weren't seen at all. So Peyton v. Mississippi established that the systematic racism within the criminal justice system. And so when it comes down to picking juries, we have that same type of track record. It's called Batson, Batson, Batson. You know, coming from the neighborhood I come from, and I always got to bring up the Bronx. You know, it's funny that this case is called Batson, right? Because when you realize what it's about, and I'll tell you in a second, you want to take a bat and you want to bat son. You want to bat someone, as they nickname son. You want to bat someone. So you want to bat someone. So you, right? So I make fun of it, but it's true. And so what does Batson says? Batson says that if you find any party, prosecution or defense, systematically excluding people off the jury because of their race or their gender or some other discriminatory element, then you have to show that there's a pattern in practice of it, and then you can raise a Batson challenge. You can go before the judge and say, Judge, look, we went through 3 panels. Yeah, we have African Americans on this jury, or we have Latinos on this jury, but guess what? We don't have any Latino males. We only have Latino females. And every time I come up to pick one, he used a preemptory or she used a preemptory challenge. Here it is. Here go my board. Here go my little cheat sheet. Mr. Rodriguez, Mr. Lopez, Mr. Armando, Mr. Luciano, all out. Mr. Ortiz, all gone. We have Mrs. Lopez. We have Mrs. Rodriguez. We have, Mrs. Ortiz, but we have no Latino males. That's a pattern in practice. Judge will review that, look back at that, and maybe decide we want to bring back some of those jurors that we excuse. Put the prosecution on notice or defense on notice. I see what you're doing. And so it doesn't have to be color. It can also be gender. It can also be occupation. It's a pattern in practice. If you only have postal workers, if you only excluding UPS workers, if you only trying to create a jury that is only of, you could be challenged. That's the U.S. Supreme Court. It may be part of what we see in the police officer Shaven's case. I wouldn't be surprised, a case of this magnitude, that something like that comes about. So we have to be culturally involved. We can't sit on the side. And before we segue into what's going on in Minnesota, which is important, in Minnesota, they do have a preemptory challenge system. But guess what? The defense get 15. The prosecutor gets 9. So if you're a prosecutor in this particular case, and you're trying this police officer for the death of George Floyd, and you walk in that courtroom and you only got 9 challenges, 9 is not a lot. 9 is not even double figures. It's 15 is a lot. Now, because of the sensitivity of the case, the court might even this up and say 15-15. In federal cases, that is what happens sometimes. Everybody has an even amount, but we don't know. And so we're in the midst of that jury being feathered out right now. So I'll pass it over to you, Dr.
Well, thank you, Richard, for your comments saying great information, didn't know that, and, seeing the point of what happens. But that's amazing if it doesn't get evened out. 9 versus 15. I hope people are active out in Minnesota as far as, serving on juries. This is such a high profile case. It'll be interesting to see what the final pool is. But the news, of course, has been covering it and talking about it. And I know we're going to just do a live feed on what's come out. I mean, there's everyday breaking news about this particular case because we know it sparked the next layer of the revolution when it comes to criminal justice reform, watching this murder happen. So I am definitely interested to see how this plays out. Here's one of the news channels and their coverage of this particular jury selection.
Minneapolis officer Derek Chauvin began with jury selection. It won't be an easy process finding impartial jurors in a city deeply impacted by the image of George Floyd's last moments. CBS's Jamie Yukas reports tonight from Minneapolis.
You have been summoned as potential jurors.
Jury selection started a day late, so lawyers wasted little time.
I want to make sure that what you would apply would be the Minneapolis Police Department's standards versus your personal experience being trained in jiu-jitsu. You would do that?
I would do that.
The dismissal of minority potential jurors drew an objection from the prosecution.
The defense has made its preemptory challenge now, and it's the second person of color in the jury pool.
The streets were calmer after hundreds marched around the courthouse Monday. But in a city that has seen violence surge since George Floyd's death, including a 14-year-old who was killed last night, many young people feel trapped between the violence and the police that patrol the community.
I feel like I'm hunted.
17-year-old Marcus Hunter lives with that threat every day.
When you go to bed, what do you hear in the neighborhood?
Constant gunfire.
Have you felt targeted by police in the past?
Yes.
In what way?
Every encounter that I've had with the police has been unpleasant.
He's written 2 editorials for the Minneapolis Star-Tribune, trying to explain how he sees what's happening and what's at stake in the trial downtown.
I compare a lot of myself to George Floyd and Michael Brown and Trayvon Martin and those who have died to police brutality. And to me, it means change.
There were 3 jurors selected today, including a woman related to a rural Minnesota police officer. Jury selection will continue tomorrow, despite prosecutors saying that the judge doesn't have jurisdiction over the case as they await a ruling on a lesser murder charge. Nora?
Jamie Yukas, thank you.
Wow. So they're waiting. I think that's significant. They're waiting to see if that judge gets overridden.
Well, here's the reality of it. The appellate court will review whether or not the third charge, which is third-degree murder, will be part of the case. But they're not going to ask this judge to start all over, remand the case. That's what we call remand. That means start all over. This is one of many charges. Right now in openings, we're not even near openings. We're just in jury selection. So no one is discussing the law. You're trying to get to know whether this person is just a fair mind and sound body. And you have to do that in 15 minutes or less. And you have to do that by way of a questionnaire, in this particular case, that the jurors had to fill out. And you're asking from that questionnaire. So we're not even getting to the law. I know that's good feed for the media. And we have to be very careful in this particular case about the media, because we already see slants as if this case cannot be tried in Minnesota, as if we have to go to Pluto or Mars. We've seen in America, we've had people that participate in terrorist acts. And we all know Americans can't stand terrorist acts, but yet they went on trial with Americans as their jurors. We've seen that in federal court in New York and in many other states. Oklahoma shooting, bombing, you name it. Folks have been on trial in cases that have nationwide media coverage and have touched them profoundly, and they've been able to move forward and convict or acquit. And the narrative that it is going to be so difficult to pick a jury, I would like to strike that narrative, say it has been done before, and we will be able to do it again, and we should be able to do it again. And to my point earlier, that young man who's 17 years old or 16 years old, who's writing these articles to the newspaper about his experiences, he's only 17. When he's 25 or 26, will he be able to participate as a juror? And if he does, who's going to be the wise guy, prosecutor or defense, Googles him as a juror and says, Judge, he may not be fair because he wrote these articles about the criminal justice system, putting him in a box as if he can't be forward thinking, putting him in a situation where one has to err on conservative and be conservative and say we have to strike him because he might be biased, rather than looking at him as a person that told the truth in his time and space about his experience and only about his experience. He's not writing about what this does to my mental makeup if someone of brown or black skin gets caught shooting, stabbing, stealing something, or whether or not he can make the determination as to whether a police officer acted wrongfully or was using misconduct or acted rightfully or in the right way. He's given the experience. But once again, the narratives will be told for that person that can create a scenario. And so I just briefly want to educate our listeners, and I'm going to look to the left because I want to read this to make sure that we all understand this because you brought it up. Jury selection is going on. It was told for a period of time because it had to be decided, and it still has not been decided whether or not the appellate court is going to allow the third-degree murder charge to come in. And the third-degree murder charge just says, without intent to effect the death of any person, which is different than some of the other charges, second-degree murder, which may cause for an intent, not premeditation, but an intent. This says without an intent, which is important. That means I did not intend to do this today, but it happened, to affect the death of any person. So to affect the death of any person, affect the death of George Floyd, the person who died, causes the death of another. And now this is where everybody's getting caught up. Of another. Does that mean of somebody else? Or does it still mean of the person that is dying, that's being attacked? I believe it means the person that's being attacked, not another person, right? By perpetuating an act eminently dangerous to others and evincing a depraved mind, that means you don't care, without regard to human life, is guilty of murder in the third degree and should not be sentenced no more than 25 years. And so where the decision is and what the court is really ruling on is death of another. Do you really mean another person, or are you talking about the individual that you started out with? And by perpetrating an act eminently dangerous of others, or eminently dangerous to others. So if he is perpetrating an act on George Floyd, how is that dangerous to others? And what the defense is saying, look, the statute doesn't apply because it talks about dangerous to others. The danger was to George Floyd. And what the prosecutor is saying, no, it does apply. And so that is the ruling. But that does not mean that juries cannot be picked. This case cannot go forward. And that is what is happening. And it is unfortunate that the style for which they're doing it, as you saw, the prosecutor and the defense, they're asking questions based upon a questionnaire that they receive. And I will tell you that picking a jury is the most important part of a trial, because that is the first time that you get a chance to connect or disconnect with a juror. Let me repeat. That's the time when you get a chance to connect with a potential juror or disconnect with a potential juror. And you have to ask them questions when you do it based upon a questionnaire, which in state court, a lot of times there isn't a questionnaire. So you can get a chance to get more information and talk to the jurors personal things that are on a questionnaire. Now, you gotta tread lightly because you don't want to appear to be intrusive. You do not want to appear to be, I'm just going to use the word, an asshole, someone that is an idiot, someone that is not sensitive. When people write down certain information that they want you to be aware of. All right. Now, that doesn't mean that you don't get to the truth, because if you don't get to the truth, you may have a jury pool made up of people that are not fit for this trial. And what do I mean by that? In one of the news media clips that I saw, the prosecution was asking an individual who said that they don't know if they can sit on this jury because they were afraid of threats, being targeted, being ostracized, being threatened, being pointed at, being written about. And then they said something to me that hit a bone that the prosecutor did not pick up on, or maybe did and decided not to address it because it treads on that water that you don't know whether that water's shallow or whether you're going to hit the bottom of the pool very quickly. And the potential juror said that I'm worried about my house being spray painted. Now, once again, this is speaking legally, where the culture and the legal meets. Culturally, in my brain, when I heard that, I automatically went to, well, who is he thinking on spray paint his house? Got to be talking about protesters. Got to be talking about black and brown folks, because he was talking about his house being vandalized. He wasn't thinking to me about police coalitions and Blue Lives Matter and how he might be targeted by those in law enforcement. What he was saying and how he was saying it and what he was talking about led itself more to those that are marching in the street, which are brown and black people, than it did to law enforcement. So what I got from it, and what the prosecutor didn't talk about, is, sir, who are you talking about? Are you worried about protesters who are brown and black people spray painting you sometimes got to go there to get the answer to your question, because if he's sitting on that jury, you may have a problem. And there's something to be learned by exploring that for other jurors.
Well, there are also allies. I think we have black and brown and, allies that are, white citizens who just know it's wrong and they're just tired of it. But to your point, that would be an inference that I would definitely come away with, like, wow. And you heard the other gentleman in the clip, I believe it was the prosecutor, mentioned that 3 African Americans were turned away or rejected. So it's going to be interesting how this continues to unfold, getting to the jury pool that will prayerfully get.
So that's to your point when he said judge. Defense has already used 3 preemptory challenges, and they were African Americans. That brings you right to the Batson. BATSON. You want a bat, son. That brings us right to it, because he's setting the groundwork, saying, judge, he's already precluded African Americans. Now the judge may say, all right, that's not a pad nor a practice, but I'll keep my eye on it. Now defense got to go to his client, the police officer on trial, and say, we got to tread easy. So we may have to let some in the door, despite what your instincts tell you, that if they're of color, then that means you're getting convicted, because that's what his instincts is telling him. If they're black or brown, then that means conviction. So we have to be careful, right? Now, we know as a people that's not always the case, because we've seen cases go into grand jury where people have been victimized by the police. We could talk about Ramarley Graham. That happened here in New York. He shot in his own home in front of grandmother and child, goes in a grand jury, get an indictment, goes back in the grand jury, no indictment. You go on in other cases throughout the United States, you're looking at the jury pool, the grand jury pool, and they come back with no indictment. So because you are of a certain color does not mean that you're always going to vote a certain way. But in this trial, that's the trigger points. And so the prosecution raised their hand, whether they were right or wrong, to put the court on notice that this is where we're going. And the court will admonish defense counsel and will take note of it, because if it happens again or down the road, you'd be surprised what the court will do. The court may call back those people that were excused, ask them some other questions, because just because you're excused doesn't mean that you go back home. I mean, in some states, you're excused for this case. You go back downstairs, you might be picked for another case. You don't just like, all right, I'm out, that's it. No, you go back in the jury pool. So that's what we might see in the near future.
It definitely will be interesting to watch, because the whole world is watching, just as they were during the height of what we witnessed in 2020. And the whole reason for the protests to continue was to keep the pressure on so that justice can be realized. So, family, as you know, Speaking Legally, we're always here talking through and giving you the information with our legal experts about what we see in their areas of expertise, which include criminal, civil, and immigration law. And, every now and then we touch on some of the other subjects that affect us culturally and what that looks like as you're arming yourself with information and resources that we provide you so that you can be ahead and not behind when it comes to what you see transpiring, and being an active member. Be civically engaged. All of us have our careers, our jobs, our businesses, and we're going to and fro, carrying on our activities on a daily basis, but know what's happening. Be aware of the people that you're electing to protect your rights, the people that you're electing to ensure that you have the right for happiness and the pursuit of happiness, rather, and be able to all these things in the Constitution. We talked about the whole show amend and understanding what that means. I think so many of us go through our day-to-day lives not understanding that somebody's controlling what's happening to you. And either you know about it and you're participating in it, or it's just happening around you and you fall prey to lack of knowledge, which is the worst offense, I think, possible while living. So let me see what our viewers are saying.
One of the things that we spoke,
you're welcome, Kevin.
One of the things that we spoke of early on in one of our mini series was that the positions that are elected and appointed, what I call elected and selected. Selected means that you're appointed by somebody behind the scenes. Elected means that you have to actually go and vote. I don't know what system Minnesota has. I don't know if that judge was elected or selected. And that makes a difference in everything that can happen. And I'll leave us with this because I know time is running short. I'll leave everybody with this. What we're asking as lawyers, or at least what I ask, is that you take your life experiences with you in that jury room. That's it. Take your life experiences with you. But here's the problem. If you're not in the room, how can you take it with you? So participate. Be a part of the solution. Don't exacerbate the problem. And once you take your life experiences back there with you, everything else is irrelevant, because we're asking you to take the facts, mesh it with your life experiences, and come up with a conclusion. If there are facts there that doesn't mesh with your life experiences, some people say common sense, but I don't want to use that word or that phrase because sometimes sense ain't so common. But life experiences are what they are. And that is what we ask you as advocates to take with you as a juror. But you got to be in the room in order for that to happen.
Absolutely. So thank you all for tuning in. Hi, Kia. I appreciate you joining in and being a part of the show today. And everyone that's here, Deborah, Richard, who do we miss? If I missed you, I'm sorry, but we'll go back through and see. But thank you so much. And if you're catching the replay, just hashtag replay so we know that you're listening and that the information that we share here is helpful to you. Remember, share cardiac arrest with somebody, cardiacarrestbook.net. You can actually give it as a gift, how to handle unlawful police stops. So it's a tactical way for you to utilize a lot of the information we talk about here on the show. You can have something in your hands and you can give it to the people that you care about so they too can be armed with information. So we'll be back again next week. We are hoping that Mr. Pichardo's case went favorably for his client while he couldn't join us today. Be safe out there. We know that we're still dealing with the pandemic. It hasn't gone away. And we'll be back again with you 4 p.m. Eastern Standard next week, Wednesday. Bye-bye, everyone.